Hi everybody, my name is Leena Yousefi and I'm a Vancouver family lawyer. Today I'm going to show you how to do a notice of family claim, seeking a claim for divorce. These forms are very complicated, they can be rejected by the registry, and for people who don't have all the money to spend on a lawyer to do them, I think it's important that I do this tutorial and teach you guys how to do it on your own. It doesn't mean that you're not going to make mistakes or it's not going to get rejected, it's just a guidance and some sort of help when you're trying to do it on your own. So without further ado, I am going to start. So the first thing you do is you go on Google and you put in BC Supreme Court Family Forms. Press enter. At the top of the page, you will see Supreme Court Family Rules Forms, Province of British Columbia. You see this page and you scroll down until you find Notice of Family Claim. It's Form 3. So you click on that, and when you click on that, it will automatically download as a PDF form, which you can click on, and then it takes some time and then it generates the form. However, for today's purposes, I am going to use a Word copy because it's a lot easier. You can't find the Word copy online, unfortunately, so you're stuck with the PDF, which is a little bit tough. But in any event, let's start explaining what this form is and what it means. So when you generate this form, you see something called court file number. You don't have to fill this out. You will get a file number when you file this claim, so you don't have to worry about this. Court registry you should probably put in. So if you want to have a case in Vancouver, so you just put Vancouver. If it's New West, you just put New Westminster. It can be Chilliwack, it can be Prince George, it can be anywhere you're living, but you have to make sure that there's a Supreme Court in your area and what the closest is. So you can't just put the name of your city. You have to make sure that that a court exists in your area. So this you don't have to worry about. Here you're a claimant because you're making a claim. So what you put here is your name. Usually I just center it because it's cleaner. And what you do here is you put your name. So my legal name is Leena Yousefi, but you should also put what you're known as. So I'm better known as Leena Yousefi, or better known as best lawyer in the world. No, I'm just joking. So I am Leena Yousefi, aka Leena Yousefi. Now the respondent, fortunately I'm not suing anybody, but if I was going to come up with a hypothetical name for my ex-boyfriend, I would put Adam Smith, aka George, or Adam George Smith. I'm including the middle name as well. So you fill this out. Now, in this section, there's just a bunch of stuff that you need to read about. I can't comment on them because they're quite self-explanatory, but I just want to go where you input the information. You can see here it says information about the party, and it says complete the following for each claimant. So when it says for each claimant, there could be two people suing one person, or there could be three, or it could be one or another corporation. But in most cases, it's just one person suing another. So in this situation, I've only included one claimant. Now, when you go here, it says the claimant is, and then in the bracket, it says briefly indicate that person's relationship with the other parties to this family law case. So what I usually say is claimant is the spouse of the respondent. You can say the claimant is the wife of the respondent. You can say the claimant is the common law partner of the respondent, whatever you want to say. You just have to indicate what the relationship is here. And then you see a section here, it says the respondent, and it asks the same question. So you can just simply say the respondent is the spouse of the claimant, or you can say the husband or common law or whatever, just like above, but make sure that you keep things level. So you can't say spouse for the claimant and then change husband for the respondent. Keep them uniform. Now, with spousal relationship, this is just asking you to explain what the relationship is. I usually get rid of all this gibberish, but in any event, this is what you have to fill out. So if you lived with somebody as a common law, or you lived with them and you felt like you were married to them because it was so serious, you can put when you started living together, so month, day, and year. So I can say September 8th, 2017. And then if you were married, you just put the date of the marriage here. And in order for you to file this claim, you have to be separated. So you have to fill this out. You can't sue somebody while you're in a relationship. So you have to be with them. You have to be separated from them. So you put the separation date. Now, couples may disagree on what the date of separation is. Here, you just have to put what you think the date of separation was. It's not dependent on an event or anything. It's just when you felt like this relationship was irreparable and there was a separation. In some situations, people sue each other even after they've been divorced. So if you've been divorced, you can fill out this section. Section 3 is prior court proceedings and agreements. So it's very important so if there's been an oral agreement, you don't need to worry about it. But if there's been an agreement, even a handwritten agreement, a prenup, a separation agreement, any agreement, if it exists, you have to go and click this area and say that there's been a written agreement. And you have to indicate the date. If there's no agreements or court orders, you just go and click here. But if there is an agreement, you just click here. Sometimes previous court orders have been made, so you have to indicate the court orders, and sometimes there are prior court proceedings. This topic is a little complicated. Some people, for example, have a claim in the Provincial Court of BC, and then they have another claim in the Supreme Court of BC. So there could be prior court proceedings, so you just put in the file number and the court registry. And then in this section, it talks about the claimant's claims. And for today's tutorial, the only claim is divorce. So I'm not going to worry about the other claims, which I just mentioned at the beginning of this tutorial. The place of trial will be, so whatever registry that you picked, for example, up above here, when I showed the registry here, if it's Vancouver, you basically put the address of the registry here. And the Vancouver registry, I know by hand, it's 800 Smythe Street, Vancouver, BC. Place of trial is the exact same thing, 800 Smythe Street, Vancouver, BC. And then your address for service is the address that your ex or whoever else can serve you with court papers. So because I'm a lawyer and I'm representing my clients, I just put the address for service as my address. But if you don't have a lawyer, you need to put your home address here and your phone number. Now, be careful here when it says email is optional, which it is. But if you put your email address here, everybody can serve you through email. In some situations, people like to give their email address because they will receive everything immediately. But in some situations, they don't want to put their email address. They just want to be mailed documents. My recommendation is for, making it easy on everybody. It's best to put your email address. I don't put my email address because I have a fax number, but many people who don't have lawyers don't have a fax number, and it can take days for mails to arrive, especially if there's something urgent. You don't want to make somebody run around and try to get something to you when in fact they could just email it to you. So here it says signature for lawyer for the filing party. If you don't have a lawyer, you just say signature for filing party. And again, I'm going to get rid of this. You can say just Leena Yousefi and or your name or whatever it is. Make sure the date is accurate. This section, if you don't have a lawyer, you don't need to fill it out. This is what I need to fill out as a lawyer to basically advise my clients that, of other ways to settle or get back together or reconcile and whatnot. So if you're only claiming divorce, the only schedule that you need to fill out is the divorce schedule, which is Schedule 1. And what you do is you put each other's birth, like you put your birth date and his birth date or her birth date, depending on what gender you are. Ordinary resident of British Columbia. This is very important. If generally, if you've lived in BC for less than a year, you can't ask for a divorce. If one of you has lived in BC for more than a year, you can claim for a divorce. If neither one of you has, you can't claim for a divorce. So when you put the dates here, the registry checks the dates. So I can say I've been resident since September of 2017. If I say my husband has as well, this is going to get rejected because they're going to say you haven't lived here for a year. So one of you guys will need to have been living here for more than that. So let's say my boyfriend, husband, whatever, has been here since 2015. Now you're good. This is not going to get rejected because you've been here for more than a year. Surname at birth is self-explanatory. You just put your surname before getting married or at birth. And then, yep, this one's surname immediately before marriage. You put that. Marital status, you fill this out. Place of marriage, pay attention that it's city or town, province or state, and country. So, for example, Las Vegas, Nevada, US, or Vancouver, BC, Canada. And date of marriage. I don't know why they have two columns for this. Obviously, these two people got married on the same date. But in any event, you just put the same date. Like, for example, again, September 2018, September 2018. Grounds for divorce. This is where you have to pay careful attention. So the first thing you have to fill out is the claimant asks for an order for divorce on these grounds. There's 3 grounds to apply for divorce. Number 1 is that you've lived separate and apart since, and so I can put here, like if my date of separation was September of 2017, I just put this and click this. Now, if you've been separated for less than a year by the time you're filing this claim, so right now we're in June of 2018, and I'm saying we separated in September of 2017. It's been less than 1 year since we separated. So the registry is going to accept this form, but they're not, if you apply for divorce right after, like you have to fill out some other forms to apply for divorce. But after you file this, you have to wait a year before proceeding for an application for divorce. If you proceed for an application before September of 2018, your application is going to be rejected because the law says that you have to be separated for more than a year. And then you see this word, it says and. So and means that you have to fill out this section, like one of these two needs to apply because it's not an or, it's an and. So the claimant and his or her spouse have not lived together since then, which could be your case. And if you try to reconcile for a period, you can fill that out, that we tried to live together in an unsuccessful attempt to reconcile, and give the dates of the reconciliation, but then state when you permanently separated again. Now, you see or here. This is because there's 3 grounds for divorce. The most straightforward is being divorced because you've been separated for less than a year. The other 2 grounds are adultery or physical and mental cruelty. My suggestion is, even if you have experienced adultery or physical and mental cruelty, it won't really be worth your time to ask for a divorce on those grounds, because you may have to go to trial and prove that you've been abused, or your husband has cheated on you, or your wife has cheated on you, and the standard of proving the actual act of sex or the cruelty and the time it takes to prove it in front of a judge at trial just makes it longer and more expensive. So I would just take the path of least resistance and just say that we've been separated for more than a year and we haven't gotten back together. But anyway, if you insist, you want to press this other grounds, so you have to get rid of these. You can't apply for all grounds there. You need to pick one ground. You say other grounds, and you have to click this. It just means that you haven't done anything wrong, but the other person may have. Now, you have to confirm that there is no possibility of reconciliation. If you don't confirm this, you may not get a divorce. You have to say that there's been no possibility of reconciliation and that there's been no collusion. This means, for example, for people from other countries getting married just to come and immigrate to Canada, it means that it's marriage by fraud or collusion. So you just need to confirm that your marriage was legitimate. This is something that is absolutely required. If you don't file the certificate of marriage, your notice of family claim may be rejected. So you can choose that you filed it. If you don't have it yet, you put this in and you say it's not being filed, and you have to state the reasons. Reasons have to be valid, legitimate, and urgent. So you can't just say because I don't have it, because they're going to say, well, go and get a copy from the vital statistics. You can say that your husband has it and he can file it, and so forth. But you have to state the reasons, and they need to be good reasons. Or you say it's impossible to obtain a certificate of marriage, and you have to state the reasons. This is usually in very extreme circumstances. For example, you got married in a third world, let's say, country 30 years ago. There is no record of your certificate, and you have to, in addition to everything else, at a future date, you have to swear an affidavit and follow very complicated procedures. So if you can get a copy of your certificate of marriage, that is the easiest path to follow. And then you talk about children. If you don't have any children, you say no children. If you do have children, you say yes, I do. Then you put their name, birth date, and who they reside with. And again, you sign, put your name here. And again, this is a lawyer certificate, so I'm going to get rid of it. And there you are. So if all you're asking, Schedule 2 is children, child support, and so forth. If all you're asking is for divorce, you only need to come down to this section. And as soon as you get to Schedule 2, you can delete everything that the rest of the form, because the rest of the form is all about, child support or spousal support or property. So you delete everything, you sign this, and you go and double check that everything is accurate, all the spellings are okay, and you filled out everything. Just be very careful if you don't pick, if it says or, you have to pick something. If it says and, for example, here, if it says and, it means you have to click this. See, I forgot to click this, so it's good that I'm reviewing. And you have to click this as well. So if you don't click these boxes or you miss something, your notice of family claim will be rejected. So once that's done, you make 4 copies. Usually we recommend 4 copies, and you sign all 4 copies. You take this form to the registry. So Vancouver registry is at 800 Smythe, as I showed you. So you go to the registry, you file them at the family desk. They will take one original copy for themselves, and by original I mean it has to have your original signature, and they gave you back three forms. I'm going to put the camera back so you don't get bored. So you get back 3 forms, and from those 3 forms you keep one, your ex, you give one, you serve your ex with one, and the third one is just going to lay around there in case you lose the one that you have. So I think that's it for now. I will follow up with how to fill out your notice of family claim for other claims, but for divorce, this should give you a good idea of how to do it, what to do, when to do it, and what procedure to follow. I hope you enjoyed this tutorial, and I will be back.